Forward and Out has been made possible by the generous support of the following: The Loft, Lesbian and Gay Community Services Center; Choice Travel; Stephanie's Living Room;
The legal rights of marriage are not afforded to same-sex couples, and never have the consequences of this been so poignantly revealed than in the Sharon Kowalski-Karen Thompson case. Although Karen Thompson was ultimately named Sharon Kowalski's guardian, it was not without years of anguish and legal battles. There are legal measures available to our community which can prevent such torment from happening. Until we win our battles to end every discrimination against homosexuals, it would behoove each and every one of us to get our legal affairs in order now. I'm your host, Eileen Karn. Our guest on this edition of Forward and Out is attorney Kelly Donovan. Her practice focuses on estates, wills, real estate, and advanced planning. Grab a pen and take notes. Kelly has lots of information and advice for the lesbian and gay community. Welcome to the show, Kelly.
Thank you, Eileen. It's nice to be here.
Can you review that Kowalski and Thompson case for us? That was a very important impact type of case.
Sure. Basically, Sharon Kowalski was in a very bad accident and was seriously injured. Karen Thompson was her partner. They'd been together quite a while at the time of the accident. Because they had not made any legal planning, any legal documents ahead of time, Sharon's family stepped in, swooped her up, and took her away. Would not allow her partner, Karen, to see her or have any rights about what happened to Sharon.
Was it just that they felt Thompson was inadequate to the caregiving
No,
type of
they were
task?
seriously opposed to the
homophobic.
lesbian relationship also, and felt this was not right. They actually denied that their daughter was a lesbian, and basically implied that this was all a creation, all in her partner's mind or in her imagination. So her family picked her up, her family picked Sharon up and took her away, basically. Kept her partner away from her for many years, would not let her partner be named her legal guardian, would not let her visit her, have any rights or any say in what happened to her.
And
it was only after many, many years of fighting a legal battle and raising money around the country to do it that Karen was finally named her legal guardian within the last year, I believe it was.
Really, just this last year that happened?
Yeah, that was
many
years.
Case has been going on for years.
Yeah, and what's perhaps saddest about it is there's certainly the suggestion that needed care was denied to Sharon for many years because her guardians did not take the proper measures. Maybe that care would have resulted in her recovering more fully from her injuries.
Right. So
we'll never know.
So
we'll
the family taking over Sharon's care created a reduction in...
There's certainly a suggestion of that. There's certainly a suggestion of that, so it's particularly tragic.
So her loving partner could have done a much better job as a...
Certainly her partner had a lot of training specifically in this area and has done a lot since she has been named as her guardian. She's done enormous amounts, but it was many years after the accident, so we don't know.
So that's a big lesson for all of us.
Yeah, it has been. And I think what's helped a lot is that over these years and going around the country, partly to raise money for the legal battle, Karen Thompson has spread this word. And I don't know if you've ever heard her speak or seen a film of her speak, but she's very effective, very moving.
On the idea of putting in place legal protections.
Yes.
What does that involve? What sort of legal instruments would be used?
There's a couple of categories that I like to talk to clients about. One is the whole area of I call advanced directives. These are documents which we execute now while we're adult, competent, when there isn't any emergency, when we're not in the hospital, preferably. And what they say in various guises is what we'd like to happen, who we'd like to be in charge in some emergency in the future.
In the eventuality.
In the event that we were in a bad accident, if we were in a coma, I mean the worst possible, but even if we just were unconscious for an hour or two, who do you want to be making these decisions? Who do you want to be speaking for you? So this whole area, and I can talk about the specific documents in a minute. The second area would be wills. They take effect only when you die, your will. So that's planning for what happens after you're no longer here. Another area is other agreements that take effect now, such as living together arrangements, parenting agreements, things we may not have time for. But the advanced directives, I think anyone should consider doing, whether you're gay, lesbian, heterosexual, whether you're single, coupled, married if you're heterosexual. Anyone should consider that.
To be done in advance of a potential problem.
One of the most important, I would say probably the most important for anyone to consider, is called the healthcare proxy in New York. Let me say as an aside that I'm going to be speaking really only about New York law. And
they vary from state to state.
That's right. This varies considerably. The principles are the same. Some states have documents that are similar, but they might have different names. What we call in New York a healthcare proxy is sometimes known as a medical power of attorney. But in New York it's a healthcare proxy, and it is, I think, perhaps the single most important document for anyone to consider. With this, you name somebody to be your healthcare agent and to make decisions if you should be unable to, for any reason, whether it's because you're having surgery for a couple of hours or because you're no longer mentally competent. So it runs the gamut, but it's a document that's in place. It is binding by New York law. It must be followed.
Does that include the, like the pulling the plug issues, or is that
Not
a different?
Not really. That's a different document.
To decide whether resuscitation or
That's right.
measures.
Your healthcare agent that you name in the healthcare proxy, the agent you name, does have very broad decision-making power to make all the decisions you could make if you were able to speak for yourself.
So
when it gets to pulling the plug, New York is still a little, as most states are, it's not quite clear yet how much power that agent would have.
That agent would have. It was a decision made with medical authorities, and it's more a comprehensive decision rather than just one person who's been named in this document.
It may be. Right. That gets very specific to each case. Exactly what's your condition and exactly what are you hooked up to or not hooked up to.
I see.
The document you may be thinking of is something called a living will. That's another document people should consider executing, and what it does is express your wishes about what you'd like to happen if you're in a hopeless terminal condition with no hope of recovery, no hope of getting back to a normal life. That's not binding in New York. It is some record of your wishes, though. If you feel strongly about this area, it's a good thing to execute. And to talk to your healthcare proxy about. Say, if this happens, here's what I'd like you to do.
So whoever you name as an agent would know your wishes through this instrument.
Well, I certainly encourage people to talk to their agent
Yes.
about anything they'd want, about all the ifs.
Right.
And a lot of people, of course, have difficulty facing any of these questions.
Right.
I don't want to talk about what might happen if I'm in a coma. I don't want to think about it.
Right.
Or I don't want to do a will. I don't want to think about dying. So it's a struggle for many people to address these things at all.
It seems like the older we get, the less we want to look at it.
Well, sometimes it works the other way.
Oh, yes.
Because sometimes we see what happens to our contemporaries when they don't have these documents.
There's other legal instruments that are available to us. I think we discussed something about a nomination of guardian. And
yes.
What,
along with the healthcare proxy and the living will, another possible document to consider is a nomination of guardian form. With this, you would name the person whom you would want to be your guardian, your legal guardian,
so
if you were no longer
named Karen if she had had this?
If this document had been
Been in play.
available in her state and if she'd signed it, yeah. So now in New York we can do that, so that I today could choose someone and say, if I'm ever incapacitated and cannot take care of myself, I want X to be my legal guardian.
Right.
The court then should pay attention to that. The court still will name the guardian, but we hope that they take into account my wishes that I wrote down.
Yes.
Yeah, so.
And priority of visitation, that comes in the health.
Priority of visitation is a created legal document created by lesbian and gay attorneys. It's more of an invention, in all honesty. It is not legally binding, but what it says is, I want my partner or my lover to have priority in visiting me in any situation where visiting might otherwise be restricted, like
To family.
an intensive care unit
right.
of hospital. We've found it to be effective in some situations, but not always.
So you could go to the hospital administrators or whoever made the
and
rules and say that this
say I have
document's
this
in
paper,
place.
right? And
yeah.
it may help. It's it's not binding. The healthcare proxy is a better bet, although the two may go together. The healthcare proxy, by naming your agent, your healthcare agent, to make decisions, I think that person must have access to you.
Right.
Otherwise, she could
Yeah.
not make a decision about you. So I think
Right.
it guarantees that implicitly.
Right.
Yeah.
Is a healthcare proxy then an absolute protection? Is it quite sacrosanct?
It's nearly.
Yes,
As absolute as anything can be legally, I'd say, yeah.
Right,
The statute
so-
says it's binding. The statute says doctors and hospitals and any institution must pay attention to it, must follow it.
Right.
Very strong document for lesbians and gays in New York.
Right.
Fairly new, just came in 1991, and not everyone is yet aware of it. It's a very good protection for us. It allows the decision-making power. It allows access, I think. Very strong.
Yeah, very good. In some situations, the power of attorney is required. When would that come up, and how?
Power of attorney covers a different area. We've been talking with healthcare proxies, living wills, appointment of guardian, really about health issues. All right, who's going to decide if you can't function anymore? Who's going to make medical decisions more for you? Although the guardian's power could be broader. Power of attorney is complementary to the healthcare proxy and covers business and financial affairs. And what you do there is name an agent to take over and run your business and financial affairs if you're not able to.
So they could sign your checks and.
Yes, they can. And so it's a document I urge people to be a little careful with too, because yes, they can. Your agent can sign your checks and sell your property and.
And the power of attorney is really as though they were in your behalf. They were you in all these.
Yes, they're supposed to be acting in your interests, but it should obviously only be given to somebody whom you trust.
really trust and
very much.
who has resources and
Because
acumen.
it's also effective as soon as it's signed. It doesn't wait for you to become incapacitated or incompetent.
So I could be signing my checks, and my power of attorney could be, two people could be signing my checks.
In
if
theory.
In theory.
I like to consult with people about whom they're giving this to and what the relationship is. I have no hesitation with people who've been together quite a while, couples who've been together a long time, and whose lives and finances are mixed up, and often there's access by both anyway.
Most,
anyway.
banks.
If it was a couple who'd been together 6 months, I would like to talk to them a little more seriously about what this means.
So
not everyone's comfortable with that. I
right.
understand why.
When is the power of attorney absolutely a wonderful thing to have? When is that?
I think it's good for a stable relationship where you can implicitly be assured that it will stay in the drawer unless it's needed.
Okay.
And then it's there, though, if it's needed. What it's there for is if you're in a car accident, Eileen, and something where you just can't function, and it takes you 6 months or a year to get your mental facilities back. It's already there and in place. Someone can be paying your bills, get the mortgage paid, be negotiating your checks maybe, keep things going without having to go to court, hire a lawyer, pay court fees to have somebody appointed guardian, and maybe not the same person. You know, you get into a much less certain area.
Right, right.
Yeah.
That sort of touches on the whole area of estate planning altogether. sort of, you know, around real property and what your assets are and things.
I urge almost anyone who comes to me to consider making a will.
No matter how much they have or how little they have.
That's right. Many people come and say, I don't own anything, what's the difference? Who cares? Or my partner and I own everything together. You know, we've set it up that way so she's protected or he's protected. A couple of things I like people to consider. One is, with a will, you can name the executor or executrix, the person who will be in charge of your estate. It's a very important position because it carries a lot of power and control at a time when it may be very important to that person. If something happens to your partner, and you are named executrix of her estate, for example, it gives you the say, the power with her family, with the court, as to the timing of things, in a sense, and how things are done. It keeps you in control of your life as it remains after she's gone. It means her family cannot swoop in and say, we're taking all her pictures off the wall, see you later. Or we say as executor that this is going to happen this way. It keeps you in control, and sometimes that's very important. If you do not have a will, the court will name somebody to be in charge of the decedent's estate. And the court must follow a list, which is basically a next of kin list. It does not have the choice of, unless the family agrees, it does not have the choice, and it must follow this list. Okay, so that's one thing, is control. Secondly is to leave what you do have to whomever you want, even if it's not of value. These things are usually important to you and to someone. I had one client whose lover had written a lot of poetry. Well, without a will, that poetry would have gone to her elderly mother, who might not have appreciated all of it sufficiently. If you made a will, she could have left that to her partner or her friends. You know, that kind of thing. It's not worth money, but it's invaluable. So for that reason, I urge people to consider it also.
And then once the will is in place, how much periodic updating is usually required?
There's no magic time limit, I don't think. I urge people to consider it, think about it, have it reviewed by some attorney whenever anything big happens in your life. If you end a relationship, start a relationship, if you inherit property, if someone in your family dies, if you buy property or if you sell property, any major life change. Just have someone look it over. It may be that I certainly have looked over wills and said to people, no, it's fine, it still does what you want, leave it alone.
Then I guess once the document exists, it has to be secured properly in a safe place or somewhere where it's known that it exists.
Yeah, that's always good.
Do you recommend
that's a harder
safe
one.
Deposit
No,
box
that's
something?
where I don't recommend. And many people think of that as the safest place to keep
like it
everything.
Won't burn or,
right.
Yeah.
The trouble is that your safe deposit box can be sealed on your death, so that there can be a delay getting the will or finding out if it's in there. You have to get a court order, which is granted easily, but it means a little delay and going to a lawyer maybe, or getting the form and all this stuff. So better not there. I urge people to think of somewhere safe and fireproof if possible. If you don't have that at home, certainly I and many attorneys will hold it for you. I have an attorney's safe deposit box that just holds clients' wills. So that's
So
just
you
as
would
a
have
free
access.
service. It's not for a fee or anything. And then anytime you want it, you let me know. So
Right.
that's possible. I know the other thing that, while we're on wills, before I forget, many gays and lesbians get worried about is the will being challenged by their families. And I want to reassure people that in New York particularly, if you execute a will properly, and execute means the whole ceremony of signing, if you do that right, it's very, very, very difficult to overturn a will, to challenge it successfully.
Right.
So that if you do it right once, you can be very secure that probably it will stand up in New York.
In the courts, yes.
That is one place where I recommend you go to an attorney. I
For
don't
the
always
wills.
recommend that, but in this situation, because
Don't send away for a kit.
not on this one. You don't have
not
the
on-
trouble is you don't have a chance to do it over. You're dead.
Right.
I mean,
do it right.
literally.
The first
So,
time
yeah.
with the help of an attorney. Is
Yeah.
what you recommend.
Yeah, I do recommend on that one. It's not worth fiddling with. You can't fix it.
What about the lesbian and gay couples who own property together? Joint ownership allowed in New York State?
Sure, sure. You can own property together, and there's basically two ways, which I find many people don't know about or understand. One way is called joint tenants with right of survivorship. What that means, if you remember the survivorship part, I think it helps. What it means is if two people own property together and one dies, the survivor owns the whole thing automatically. Right? Survivor takes all, in a sense. The will
like
doesn't.
a married couple. That happens.
Well, it depends. It can. They can own property that way also.
Oh, I see.
But you can choose to. They also can choose to own it any way they want.
Oh, I see.
So the advantage of survivorship ownership is it can't be challenged in an estate because it's not really part of the estate.
Are
it's
there
just
tax
automatic.
implications for
You
that?
still have to pay taxes.
You do?
You still have to pay
Yeah,
taxes.
okay.
Everyone's always looking for a way out of estate taxes, and pretty difficult.
Yeah, the
Pretty
survivorship
difficult.
isn't going to get you that.
No, no, you still pay taxes on that, the half roughly that you owned. The other way of owning it is called tenants in common. And what that means with two owners is, if they each put in 50-50, let's say, it means that each person's half passes through her estate when she dies. So that if you have a will, it passes by whatever you say in your will. If you don't have a will, it passes by what the statutes say in New York. One thing I do want to say is for people to consider, is to review, with their attorney preferably, wills and their property ownership together, because the two interrelate. There's not a right way or wrong way to own property, but it should be considered with your will. If you own it as tenants in common so that your half passes through your estate, then you really should have a will to say what happens to that. I had one estate with very sad consequences where two people owned property as tenants in common, and one who died did not have a will. That means her half passes through her estate, and it meant her mother inherited it. And we had her mother and her surviving partner owning the house together, which was not really either one's wish.
Wishes, that's not what they wanted to have happen.
No.
What about domestic partnership agreements? This is sort of reaching for some of the legal benefits and rights of marriage. Or
Yes, well, all this
designing
is
it for
realize that a
yourself.
lot of what we talked about with advanced directives is also in the sense that when you're married, you often have a lot of the rights. For instance, doctors will talk to your spouse and let her make the decisions if you're husband and wife, for instance. So some of this is built in to marriage and not built in for us with advanced directives. Similarly, ownership agreements, yes, we have to write down on paper a lot of things that
they're sort of a
comes
given.
with marriage,
Yeah.
right? I certainly urge people to consider doing them. Many people don't get around to them. It's hard. It's hard to sit down and go through all that you need to go through. What I urge people to consider is, particularly in that area, it's a contract, which just means that it's an agreement. It's your agreement with you and your partner. Write down what you want and what you can live with. There's no point in some lawyer, me or any other lawyer, saying this is how you should do it if it's not going to work for you.
Right.
You know,
And,
I can put it in throw in some legalese and write it up for you, but if it's not something you all can live with,
Well, basically it exists between the two people.
That's right.
So even if there's not an attorney involved, it may have a function for those
Sure,
two people.
sure, it helps.
But you're recommending...
It certainly helps. Well, something is better than nothing. Even writing down anything between yourselves is better than doing nothing, because memories fade or change. And we all know couples who've broken up, whether they're lesbian or gay or heterosexual. And the two sides of the story are so different, you can't believe they were ever together. And one says, we always agreed on this, and you know, you've heard this. So if for nothing else, it memorializes what your understanding was at some point
in time, right.
to remind you of what you thought then.
Right.
If you can get to an attorney, it's probably a little better in that I might think of some points that you hadn't.
Right.
The main things I'd urge you to focus on are if it's to own property together, let's say a house, for example, how do you want things to run while you're both living there, getting along, going along with your partnership? And it can be as broad or as specific as you want. I don't know that you have to get into who does the dishes and takes out the trash, but basically, if you're going to split all the expenses, fine, something like that. Who put in the money for the house? It's nice to write that down.
Right.
And then the other big area is what happens if you break up.
Yeah, to plan ahead.
Yeah, and then again, think about it along with a will. What happens if one of you dies? Is that pieced together? And think about it with the advance directives. You know, have you given the power of attorney, for example, so that your partner could manage this house if something happened to you? So part of what can be important, and that I hope an attorney could be helpful on, is putting the pieces togetger, thinking of things you may not have.
Right. Okay, Kelly. Well, we're almost out of time. There's such
sorry,
a large area.
Yeah.
So many things. We'll have to have you back because there's a lot to cover.
Thank you. Be happy
But
to.
I really appreciate your help and the contribution you're making. Is there one area in particular that you would say is the absolute must-do if I walked out of here today? What I
would
should
say
do?
the advance directives with the healthcare proxy first. I think having the power and control when your partner, or when naming whom you want to be in control if something happens to you is even more important than what happens after you're gone.
Okay,
Yeah.
great. Thank you, Kelly.
Thank you.
Okay. We hope this show prompts you all to put your legal affairs in order. Protect yourself. Thanks for watching Forward and Out. Please send your comments and questions to us at Forward and Out, care of the Loft, P.O. Box 1513, White Plains, New York, 10602, or call the helpline at 914-948-4922. The helpline can give you information about getting in touch with Kelly Donovan if you'd like to speak more with her about legal matters. You can also ask a helpline volunteer about becoming a member of the Loft. Please support your Gay and Lesbian Community Services Center. It supports you. Stay tuned for the Loft's Community Bulletin Board directly following the closing credits of the show. Thanks, and until next time, be proud.
Your local Gay and Lesbian Community Services Center is a place to connect and get involved. Various ongoing groups and social events are conducted at or by your center, and it is also a clearinghouse for gay and lesbian information nationwide. We urge you to join, get involved, and support your community.